the case should have been called Lopez versus Nichols. It wasn't because, one, I was in Chinatown and maybe I was egotistic, but that wasn't the reason. The reason was that the data concerning Chinese speaking were much worse. My memory is there were still more Spanish-speaking students in 1970. It doesn't matter.
What was that? Official?
Right, the official data. Official data was much worse concerning Chinese speaking. And there's an old adage, you always want to bring a case with the best facts. The second reason was very simple. I thought if we won Lau versus Nichols, I thought we would in a second. That basically, it would become Lopez case, the Spanish-speaking students would basically go take advantage. And I thought if we lost, you can blame that stupid lawyer and distinguish the case. So I'd like you to know that we were not naive in terms of the national impact. I'd also like to explain to you what Ling-chi didn't tell you. Why the school district took the stance it could. Now Ling-chi, as you know, you have been wrong for 40 years. They were offering bilingual education. They defined bilingual as the teacher spoke English and the child spoke something else. That is bilingual. But the reason they didn't do it, and let's face it, this is San Francisco. These are good people. I think they were embarrassed when they lost in the Supreme Court 9-0. The reason they didn't do it was very simple. The notion of equality. Stan's career, credible, the work that he did in the area of race, desegregation busing. You think about the Brown case, you think about cases concerning gender discrimination, what Stan did in terms of colleges. That's the classic type of inequality. You take people who are the same, and they're treated differently. That's easy. Society says you shouldn't do that based on your race, your gender. The Lau case is the other side of the coin. It's more subtle, but it's an equally invidious discrimination. And that is you're taking people who are different and teaching them the same. Bottom line, they're not going to benefit from that sameness. But until the 1970 memo, until Lau versus Nichols and subsequent statutes, Paul, a lot of statutes you involved with concerning disability, we had this notion that, well, if you treat everybody the same, it's fine. And fortunately, Lau pierced that veil. So, a lawsuit is brought, and we lose every step of the way. Did great for my young ego. But I want to share something with you. It's the only really law professor stuff I want to share with you. Stan talked about a word called certiorari. I don't know what that word means. What type of professor? Certiorari means discretion. U.S. Supreme Court today, with 4 exceptions, has 100% discretion of what cases it takes. Given my politics, I would like them to take none and play golf every day. In 1973, they mainly had discretion. They were taking in 1973, because they had appellate jurisdiction, they were taking about 2% of the cases they were asked to take. 2014, they took 72 out of 9,748. Your chances of having certiorari be granted, i.e. the U.S. Supreme Court that takes the case, they're pretty small. Well, Stan and I have been lucky, we've been involved in many cases of the Supreme Court. I tell you this because the decision of the Ninth Circuit, that's the federal circuit that covers us, if the U.S. Supreme Court had not taken the case, and I think that your boss, Mr. Bork, like Nixon, what am I doing? Your boss gets a lot of credit. This decision of the Ninth Circuit, which ruled 2-1 against us, would have been the law. It would have been the law in many Western states, 8, 9 Western states, and although it would not have been dispositive, it would have been very influential in the rest of the country. Let me quote to you a sentence from that decision, which came down in early '73. Quote, "The discrimination suffered by these non-English speaking students is not the result of deficiencies created by the English language program at San Francisco Unified, but as a result of deficiencies created by the children themselves in failing to learn the English language. I don't want you to laugh. I submit to you that is still probably the majority attitude in this country in 2014. The problem is not law. The problem is not education theory. The problem is not money. Sure, in the short term, bilingual education does cost more money.